This meeting is being recorded. Got it. Got it. Take pride. No.
Ma'am, we are live on YouTube.
Good evening, everyone, and welcome to the book launch and panel discussion today. We are all very happy to have you here, and we are really thrilled to have the esteemed panelists. The book, of course, is The Global Indians and the Law by Mr. Ranjit Malhotra and Mr. Anil Malhotra. We are fortunate to have Mr. Anil Malhotra with us today for this book discussion. So I'm just going to take up a few minutes of your time to tell you a little bit about the book, and then we will have Professor Bakshi get started and introduce the first part of the book to us. The book, The Global Indians and the Law, is something which is extremely unique in the subject area that it covers, as it attempts to provide a comprehensive answer to the problems of the Indian diaspora and the global transnational Indian community, which may not find a solution in the conventional statutory laws. This publication aims to be a comprehensive commentary for the courts abroad, an aggrieved spouse, a foreign litigant, an overseas practitioner, or any layperson who simply wants to know where they stand. A compilation of case law enunciated by the vibrant Indian judiciary, rendering a yeoman's service, has been quoted for reliance. And the book covers a range of topics from nationality and citizenship issues to family and marital settlements, surrogacy agreements, child custody conflict, secular adoptions, limping marriages, succession issues, conflict of jurisdictions, and other issues of family law, law for the protection of children from a global perspective, and a host of concerning and contemporary issues for anyone who wants to understand how the Indian law and the international law will interact for someone who happens to be an Indian citizen living abroad, a member of the Indian diaspora, and someone who wants clarity on these burning issues at present. And of course, to introduce our first speaker is almost someone who doesn't really need an introduction. As Mr. Malhotra was saying just before we started, Professor Bakshi is really the evergreen academic and the trendsetter that all of us hope and aspire to follow. Professor Dr. Upendra Bakshi holds his doctorates from University California, Berkeley. He started his teaching career at the Department of Jurisprudence and International Law at Sydney Law School. He has served as a professor of law at the University of Delhi, where he is also professor emeritus. He has been a professor of law at the University of Warwick, where also he is professor emeritus. He has been the director's guest fellow at Nandes University Institute of Advanced Studies and a senior fellow of the Institute of Law as Culture at the University of Bonn. Further, Professor Bakshi is currently on the editorial board of the Human Rights Law Review in the UK, the International Journal of Human Rights in Brazil, Law in Context in Australia, Macquarie Law Review in Australia, the Journal of International Law and International Relations in Canada, Human Rights and International Legal Discourse in Belgium, and the Journal of Human Rights in the Environment at the UK. In 2011, Professor Bakshi was awarded the Padma Shri, which is the fourth highest civilian honor granted by the government of India. I could go on and on about Professor Bakshi's huge influence to everyone who is an academic in the legal field in India. But I think that time is much better spent with actually Professor Bakshi telling us a little bit about part one of this book and sharing his thoughts with us. Professor Bakshi, please.
Thank you, Professor. We did a very good job in telling people how many ways in which I've mismanaged my life at times. And that's important for other people to know so they can make more correct choices and enjoy life, rather than read judgments and legislations of the various jurisdictions. But thank you indeed for organizing this seminar, for keeping us and also in advance for keeping us in time. This was hard work because several colleagues volunteered and one or two did not ultimately join us. I'm very sorry to Samya and to Saptasri for the belated notice and very kind of them to be on the panel. So I thank all the panelists. I thank Anilji for his presence here, and he in fact is taking a substantive part of the book for discussion. In addition to his book being discussed by us, so this is an unusual event in the history of legal education that academics would approach a professional book and one of the authors of the book will be present and commenting substantively on a particular part of the book. So this is a festival of ideas. I'm glad we are all together in it. Now let me rattle off something before I come to the book. Some general points. One is the main point of my starting point of my discussion has nothing to do with the book as such, but it becomes clear why we are here. And that is, I define scholarship or describe it as simply as curiosity. Without curiosity, there is no scholarship. There is nothing to seek and nothing to find. There is no destination, there is no manzil, and there is no safar either. There is no journey and there is no destination. So it's very important to have ongoing process of curiosity. Max Weber used to say, the source of religion, all religion, lies in the capacity to wonder. You're not astonished by the universe. And what are you astonished by? And you're not astonished by cosmic questions as to how the world cosmos runs. All science is born in curiosity. All religion is born in curiosity. In law alone, we think, JGU does not think like that, hopefully, but there are always notable exceptions. We think certainty is very important, but uncertainty and taking risk is very important for knowing. So this is something about knowledge, and therefore I'm amused and annoyed by my colleagues and my students. Many of them adorn the apex sport, who specialize in various subjects. I always say we Indians are born with specialization. Well, what is specialization? Specialization is knowing more and more about less and less. That's knowing people. I'm not against super speciality. It's very important. Ranjit has just had a major, give my greetings to Mane. It just convalescing from major surgery. I understand the value and importance of super speciality. But I think in legal studies and research, one should not be born with specialisms. One should be born as generalists. And one should be teased by the difference. For example, I did an article on sociology of law reviews in India, in Delhi law review, some time ago. And I was puzzled by the fact that some people call their thing a law review, like Jindal does, Jindal JGU review or some global law review. Some people call themselves journals. Now, beyond one finding, I could not proceed by any of time. I was curious why a review is called a review and a journal is called a journal when they mean the same thing. And one thing I found more tentatively, hypotheticism one, was that journal comes from Britain. They are more fond of the word journal. And review comes from the United States. They're more, but review, JGU, for example, is a US-based type law school. If you're a British type law school, the base is set on journal. But this is curiosity, this is idle curiosity. But you must stumble and wonder all the time, not specialize in anything. And therefore, when you think of types of books that were bound in law here, I read a lot treaties, maxima, horn books, American lawyers call it, which are especially lawyers' books, textbooks, which scholars write, and lawyers also write, like your Global Indian brother. Americans have a further edition called Nutshell, jurisprudence in nutshell. Nutshells are very good, not guides. Nutshells are written by senior professors after a life of teaching experience. They are addressed to you as doing the American state bar. It's not easy to be a lawyer in America. After 4 years of law studies, you have to go, JD studies, you have to go to 3 years. You have to pass at 1 go or 2 goes or 3 goes the bar examination of the state, which is very tough. And finally, there is guidebook. I think this book is exceptional because it serves all the purposes. It is exercise, massive exercise in legal literacy. And therefore, it's difficult for academics to review, to pigeonhole it one or the other way. But about guidebooks, I just recall a couple of books, my own, I call it Buxymoron. Buxymoron, like oxymoron. The Buxymoron, but I started my jurisprudence class in Delhi University. I used to teach it by saying, we had a guidebook which was called Dookie. So I said, Jo padhega, I'll translate it for you. Dookie, wo hoega Dookie. One who studies the guidebooks will be miserable. And the only contribution which I want to be remembered, please note at my memorial function, only contribution I would like to remember is that improve the quality of guidebooks. And that's it's saying a lot because this is what students read, unfortunately. They don't read any of the other things. AGU might be different. I myself read law through Jambala. Jambala was an excellent lawyer who was Bombay, who prepared notes and passed every legal provision. And I was a first-class person. I never read the cases in Bombay. Till I went to Berkeley. Anyway, that's a long story. So I think this is coming to the book. This is a great book. In this sense, it's exercising massive legal literacy. Ignorance of law is not excuse. Secondly, it traverses many substantive areas of law. Not just, the problems don't come well defined to a lawyer's chamber. They don't walk in with a definition of problem. Problems are multiple. The problem of adoption, the problem of recognition for judgment, there's a problem of Citizenship Act, and they all dovetail with each other. So what the Malhotra brothers had in mind was to inform lay people who understood a bit of law, what the law is. And they present very complicated stories in the process. I don't know whether you tied yourself knots when writing the book, but it is so many fields at once. It's not one thing at the same time, but well-defined, narrow field, because what begins as a narrow problem ultimately touches many areas of law. And that, I think, this book is very successful in doing it. Book is also successful in, and that's a very important point for me, and I've said it somewhere, I think in a book review, because short book review, I said this extraordinary book in this sense, it floats a new concept, which is both meaningful and viable, namely global Indians. Now, who is a global Indian? In law, it means one thing. In law, it means either a citizen, foreigner. Law has three categories, as you know. Either you're a citizen, or a foreigner, or you are a mixed category, previously called person of Indian origin, and now become what is OCI, Overseas Indian. And all these are in one basket for global Indian. Other basket is interpreting the word global in a different sense. Global as opposed to domestic. That's why I've got requests of international words to comment on this. Global as opposed to international citizen, as citizen of the world, which is quite different concept of global India. To some extent, both the concepts are traversed, but mostly the focus on global Indians of one kind. As far as Indian law is concerned, foreigners, formerly what was POI, right? And I'm very weak on abbreviation for it. And OCI. And that I think is a maze. And it's a maze because, and that's my second point, I'm running out of time very quickly. The second point is the concept will have to be examined by academics carefully, more carefully and differently, perhaps. Then we find the book. But that part of the book, which is all of the book, deals with basically legal aspects, which are important. And why it is complicated is because the law is complicated. If you look at the provision of the Constitution on citizenship in part 2 of the Constitution, it's very simple. Part 2 defines who is a citizen. That matter should end. And it is citizenship law made by Parliament. Delegated legislation, law made by Parliament. What did Parliament do? Parliament passed a Citizenship Act, which is very small, and a Foreigners Act, which is very small. And up to that, everything is a matter of rules and notification, and revisions, notification, and so on. And the great utility of the book and value of the book is to bring all these delegated legislation, which are not easily available. They're published in Gazette. There is, of course, a parliamentary committee on subordinate legislation. But when it functions, and increasingly it is blocked by some opposition, whoever is the opposition. But when it functions very well. But Committee on Subordinate Legislation does not has a jurisdiction to look at whether particular delegated legislation falls foul of the parliamentary law, but they do not have time. I don't know how often the Committee on Subordinate Legislation has met to consider rules on citizenship under Citizenship Act, rules made by administration. So there's a big problem here. And maybe I'm not well versed on committees or subordinate legislation. So I think the issue is how much do we know about, how much does Parliament know that legislative and constitutional standards are followed in the area of citizenship? And I think it's very essential to read this book to know that sometimes you cannot know how hard you may try. Sometimes it is a matter to courts. And the courts take their own time. And sometimes courts don't have access to all the legislation, all the people, all the legislators. So I think it's very important to have a practitioner's point of view. And practitioners are very important because they are the link between legislation and courts. Jeremy Bentham famously said in 17th century, he said, I always say this, it's important to note, that law is made, of course, by judge and company. Whose company does a judge keep? Lawyers, not academics like us. Right? So it's essentially law is made by two types of people, agents of officers of law and the judges. And of course the legislature, the main partner. But legislature does not make it. It makes a skeletal law and leaves it to the administration to decide everything. And it does very, very often. And that's the problem. Getting the first chapter, I think one of the beauties of this book is that the authors don't walk away from difficult questions and areas. They face them. So it is largely informative, but also substantively critical, perspective oriented, what the law ought to be. There are a number of suggestions. Many of you will discuss this, but regarding Citizenship Act, the authors and the recent amendments to it, the authors say, and I quote them, the controversy is bigger and larger. The controversy about the Citizenship Act, and we should go beyond 1920 and 1946 amendment, which is done in colonial time. And there is a question about the concept of persons. Now, this is very interesting to me. Persons can be.
So sorry to interrupt you. Just if you could wrap up in a few minutes.
Thank you very much. I won't take water. Persons are citizens as well as legal persons. Right? Persons are covered by Article 14, non-arbitration, and Article 21, which applies to persons. No person shall be deprived of life and liberty. So this is extraordinary distinction. And we have today the category OCR. And OCR applies both to citizens and persons. And the Baldwin brothers remind us that controversy is bigger and larger. It can't be settled by simply administrative notification. You need to clean up the law altogether and say what you mean. And currently, I should not say anything about it because matter is sub judice. There is a petition filed by the 1,000 OCI in the Supreme Court, which now, after your book, I hope the petitioners read your book. In fact, I recommended to one of the set of lawyers to read the book. That petition is precisely on this point, that the OCI regulations by the administration are violative of Article 21 because no guidelines are prescribed. There are no legislative guidelines. Administrative work by and large issue orders and guidelines. And that's a challenge on the ground, including the basic structure. So 21 is not mere discrimination. 21 goes to constitutional. So finally, the only answer to this very vast administrative discussion is for the legislation to be more clear and more detailed. Justice Matthew long ago, my final word, said this, that it is the, I quote him, in 1973 he said, in the Supreme Court judgment, Papaya versus somebody, he said, it is unedifying in the extreme for a court to have to look at the nooks and crannies of a legislation to find what it means, what the purpose of the law is, unquote. And this is unedifying spectacle identified in 1973 should now end in 2022 when we celebrate the 75th year of Indian independence. Thank you.
Thank you so much, sir, for that edifying discussion and an introduction to the idea of global Indians. And I would now like to take the opportunity to introduce Professor Dr. Soumya Uma, who will be discussing the next part of the text. Professor Dr. Soumya Uma has completed her BA LLB honors from National Law School of India, Bangalore. While practicing law in the courts of Mumbai, she went on to do her first LLM in family law and human rights from the University of Mumbai. Thereafter, she received the prestigious British Chevening Scholarship for Human Rights, administered by the Foreign and Commonwealth Office of the UK, and pursued her second LLM in international human rights at the University of Nottingham. She then returned to her alma mater, NLSIU Bangalore, to work on and complete her doctoral research. The research focused on developing an Indian legal framework on victim and witness protection with specific reference to gender-based violence. Professor Uma's teaching and research is at the intersection of gender, human rights, and the law. She has over 25 years of combined work experience as an academic, a law researcher, a lawyer, a trainer, writer, and campaigner on gender, law, and human rights. She has served as a research consultant on human rights with international agencies, including the United Nations Development Fund, the United Nations Office of the High Commissioner on Human Rights, and the International Commission of Jurists. She has a vast experience in engaging with a variety of international and national actors and institutions, including universities, nonprofits, UN agencies, parliamentarians, and bureaucrats from India and abroad, and has researched and authored 12 books, edited and co-edited books by reputed publishers, including Oxford University Press, and written and published more than 50 articles. Today, we are pleased to have Professor Dr. Uma here to discuss part 2 of the Global Indians and the Law. And without taking any more of your time, I invite Professor Dr. Uma to please tell us a little bit about her thoughts.
Thank you, Tanvi, for that very kind introduction. And thank you to the panelists and the organizers for having me here. So I was allotted chapters 5, 6, 7, 8, 9, which form part 2 of this book, and chapter 22. I will briefly tell you what these, I will read the titles of these books, of these chapters, and then tell you how I'm going to go about with my 10 to 15 minutes. So chapter 5 is on Indian law of marriage and divorce. Chapter 6 is on marriages, domicile, and divorce in India. Chapter 7 is on matrimonial remedies in Hindu marriages when either or both spouses are living abroad. Chapter 8 is on ingredients of domestic violence. Chapter 9 is on perspectives on domestic violence and other laws affecting the family. And chapter 22 is on law of wills. As I was reading through these chapters and preparing myself for today's talk, and also, as Professor Bakshi rightly pointed out of an academic curiosity as well, when I was reading through that, when I was reading through chapters 5 to 9, in a sense, it was like I was revising family law 1 on, marriage, divorce, ancillary reliefs, and so on, because that's a course that I don't teach right now. I teach family law 2, which is on succession and inheritance. So it was refreshing to read those chapters. And also, because I have worked as a matrimonial lawyer in the Bombay courts, as I was reading through these chapters, there were also certain incidents, certain experiences, certain cases that I handled, certain people and their experiences which came to my mind. And if time permits, and as and when I think, I think it can be managed, I will try and add some of that, both in terms of my own reading and from my experience of legal practice. I mean, I practiced for about 6 years, which is a very small time in a lawyer's lawyer's professional life. But I will share some of those experiences and insights as well. So chapter 5 talks about Indian law of marriage and divorce. It discusses Hindu Marriage Act in much more detail. It does talk about Indian Christian Marriage Act, Parsi Marriage and Divorce Act, Muslim Personal Law, Shariat Application Act, Dissolution of Muslim Marriage Act, and also Muslim Women Protection of Rights on Divorce Act. But it there's much more discussion in this chapter that is focused on Hindu Marriage Act and various aspects related to that. Probably because it also applies to a larger population. So one of the areas of emphasis here is on section 1 of the Hindu Marriage Act, which not only which talks about what this act extends to, what is the extent of its application, and there what we see is that this act applies to the territories. It applies to Hindus domiciled in the territories to which this act extends, who are outside these territories. So the act has extraterritorial application. And as the authors point out, a Hindu carries with them the family law of marriage. So Hindu Marriage Act applies even to Hindus who are domiciled outside India, irrespective of their foreign nationality and irrespective of their permanent residence overseas. So that's a point which comes across very strongly in this chapter, which is highlighted very strongly in this chapter. Then the chapter also talks about conditions for valid marriage, section 5 of Hindu Marriage Act, ceremonies of marriage, so section 7 of Hindu Marriage Act, and section 7 actually says that Hindu marriage may be solemnized in accordance with customary rites and ceremonies of either parties, but where such rites and ceremonies include Saptapati, then the marriage becomes complete and binding upon the 7th step being taken. So one of the things that, and this is from my own reading, and these are some of the thoughts that triggered in my mind as I was reading through the chapter, was that this section 7, about ceremonies of Hindu marriage, they are problematic because Saptapati is an extremely Brahminical ritual. Hindu community within India is heterogeneous, many castes, many schools or many sects within the Hindu community, and not all of them or very few of them actually follow Saptapati. And yet, so Saptapati is a very Brahminical ritual, and for any other custom, yes, any other custom is allowed, but then that custom will then have to be proven. And given the British jurisprudence that came into India, proof of custom becomes quite difficult, quite challenging, because antiquity has to be proven. It is practiced from time immemorial. It has to be reasonable. It has to be moral. It has to be continuously observed. It has to be consistent, certain, compulsory observance. It should not be opposed to public policy, all of this. So this is what British jurisprudence did to India. And many of Flavia Agnes' writings focus on this aspect as well, particularly an EPW article called Liberating Hindu Women. And that talks quite a bit about this aspect. So it just came to my mind, and it triggered this thought in me that although this book explains this particular custom, it is also important to understand that for proving custom itself becomes difficult. Then the book, in this chapter, there's also a lot of discussion about registration of marriage, how registration of marriage is optional under Hindu Marriage Act, and so on, and using Seema versus Ashwini Kumar, which is a 2006 Supreme Court judgment. This whole aspect of registration is discussed. Time to time, we know that there is a demand for compulsory registration of marriages, and for declaring, thereby, as a consequence, for declaring as void the unregistered marriages. So what could be the possible consequences of these, particularly among women who may not know about this law or procedures? This was a thought that was going on in my mind, that now we have Aadhaar card which links to our PAN card, which links to our bank account, which links to our mobile phone, and we are told that if all these are not linked, you cannot file your income tax returns, right? But can this be linked to a marriage status as well? Is that possible? Is it even being thought of? I really don't know, and I'm not even in one way linking it to a marriage status could ensure that a person does not defraud, because very often what happens is there is one wife whom a person has got married to, a Hindu has got married to in a village. He comes to a city or a town, and then he marries again, and the first wife doesn't know about the second wife, and then the bigamy laws are also quite difficult. At the same time, it's also a fear. It's an apprehension in me because of the violation of privacy that will be involved. So it's just a thought that I'm putting out there. Essentials of marriage and grounds of divorce among Christians, Muslims, and Parsis have not been covered in this chapter. And of course, matrimonial laws are also very vast, and this book is already quite voluminous. So that is possibly the reason why this chapter has focused on Hindu marriages. The next chapter that I've looked at is chapter 6, which is on marriages, domicile, and divorce in India. Very often there are situations where a couple is married in India, either one of them or both of them go abroad. There is trouble in the marriage. The wife is sent back to India. She comes back to reside with her natal family. The husband then sends a notice saying that he is filing for divorce, and then this wife doesn't have the resources or the information or the network to be able to represent herself in that case, and then there is an ex parte divorce that happens, and she gets the order by post. So this is something that's been a frequent occurrence, and it's been kind of documented since the 1990s. And what this chapter does is actually to try and explain what is the position of law on these kind of situations, and it deals with many judgments. So Rupa Krati versus Anita Chaudhary is one judgment where marriage was solemnized under Hindu Marriage Act. In India, the couple went to UK, they got divorced there, and there it was a divorce under irretrievable breakdown of marriage. That was the ground. Now that ground of marriage is not available in India. And what the court in Rupa Krati's case said was that divorce order is not valid in India. So there are many other such judgments which are discussed, including Satya versus Teja and others. So where is it, this intersection between foreign courts, Indian courts, and foreign courts order, when will it be recognized by Indian courts? And Indian courts, if the marriage is in India and the couple goes abroad, even if they've got a domicile abroad, is it the local law that will apply? Is it the Hindu Marriage Act which will apply? So I think these are complexities which confuse many of us as lawyers, as academics. And I think in that sense, this chapter provides many judgments which give us what the law states. And what this chapter also talks about is mutual consent divorce filed in India by parties living abroad. So they are living abroad, but because the divorce abroad will not be recognized in India, they also file mutual consent divorce in India, but they can't stay here in India because they are residing abroad. So then what this book is telling us is that the physical parties, presence of the parties is not required, and the power of attorney holders, power of attorney can be given to the lawyers to represent them, or it can be given to others to represent them. So, and on this aspect as well, there are several judgments which are given, which are useful. And chapter 6 ends with recent Supreme Court judgments on miscellaneous issues, and this includes the Joseph Shine judgment, which decriminalized adultery, which many of you would be aware of. Chapter 7 talks about matrimonial remedies, and very clearly it says, it starts off by saying that these are ancillary reliefs, which means that they have to be attached to the main relief and they cannot be treated separately. And it talks about maintenance.
Sorry to
I have a
few minutes. Yes. Yes.
Few minutes.
Yeah.
Sure. Thanks. So it talks about maintenance, alimony, custody of children, disposal of property. All of these are ancillary reliefs. But of course, maintenance is something it deals with in the next part, which Saptarshi will be talking about. This chapter 7, talks about abduction of child by one party and about habeas corpus petition, which gets filed. So habeas corpus petition as a relief, a writ remedy, that is something that it discusses. Also, best interest of the child in child custody, because best interest of the child is a very ambiguous term. So what exactly are the best interests, that we know only through case law. So that's again something that this chapter talks about. Also, the meaning of cruelty as a ground for divorce, physical cruelty, mental cruelty, relevant judgment. So those are dealt with. Chapter 8 and chapter 9, I'm going to club together because of a paucity of time. Chapter 8 and 9 talk about domestic violence. Chapter 8 has more of an in-depth discussion on protection of women from Domestic Violence Act 2005. So it talks about various forms of domestic violence. So physical abuse, sexual abuse, verbal and emotional abuse, economic abuse. So each of these is explained and it is discussed with judgments. Also, procedure for application under the Domestic Violence Act. So filing a domestic incident report, where do you file it, what is the role of protection officers, and so on, and matrimonial cruelty and domestic violence. So these are aspects which are discussed in chapter 8, and chapter 9 takes that discussion forward, and it talks about the constitutional validity of Domestic Violence Act. And this is a very useful discussion, because many times people wonder why the Domestic Violence Act is women specific. Why is it not applicable to men who face domestic violence? Why is it not inclusive? And I think chapter 9, there are certain judgments given here, particularly Aruna Pramod Shah and Denison Paul Raj, which talk about Article 14, and very often the argument in favor of a gender neutral Domestic Violence Act is that Article 14 says equality before the law. But the authors here say, look at Article 15.3 as well, and they have discussed case law which looks at Article 15.3, which provides for special provisions for women and children, and that Article 14 cannot be read in isolation, but it has to be read in consonance with these other articles. So that is also something useful. This chapter also talks about criminal offenses and processes, Family Courts Act, and in Family Courts Act, I just want to mention it. It of course says that that lawyers are generally not allowed. That's the rule which the authors have said. But the reality is also that family courts have become extremely procedural. That a lawyer becomes necessary, and even educated parties, even informed parties cannot manage it by themselves. So by being procedural, family courts are actually departing from the spirit in which the family courts were enacted in the first place. Then chapter 22 talks about law of wills, and it talks about Indian Succession Act and the provisions, relevant provisions under that, and who are the persons capable of making wills, that it excludes minors, persons of unsound mind, requirements of proper execution of will, and so on. So Harbans Singh case of 1996 is discussed in quite a bit of detail. I think that the usefulness of this chapter on law of wills is that it is very, very relevant in pandemic times when the chances of death have increased, yet culturally many do not want to write their wills, either because they think they will survive, they think they will live much longer, or they do not want to confront the possibility of death. But for those who want to write a will, I think this chapter is something that is very relevant as well. So I think on the whole, these chapters that I read through, they provide ingredients of the law, they provide judgments, they also reproduce sections of the statutes themselves. So we don't have to go hunting to other places. Everything is there in one place, and it is in fairly easy language for anyone to understand. It discusses not only substantive law, but also procedural aspects and stages, and it discusses things like, role of protection officers, role of counselors, marriage counselors. So I think in that sense, there's a lot that has been packed into these chapters, and whoever reads these chapters is sure to be enriched by it. Thank you.
Thank you so much, Professor Uma. That was very enlightening. And I think marriage and divorce laws in particular invite a lot of attention. And to continue talking about particularly maintenance, I would like to introduce Professor Saptarshi Mandal, who is an associate professor here at Jindal Global Law School. Professor Saptarshi's research and teaching spans family law, disability law, sexual violence, and sociology of law. In a previous professional life, he has worked in various capacities in a number of NGOs in New Delhi, such as Lawyers Collective, Multiple Action Research Group, and Partners for Law and Development. He has consulted with international NGOs like Amnesty International and CREA CREA, and continues to conduct legal literacy trainings for a range of constituencies. He was a member of a subcommittee from 2014 to 2015, which was constituted under the 20th Law Commission of India, recommending large-scale reforms to child custody and guardianship laws. Professor Saptarshi's current research revolves around three themes: intercaste marriage as the object of law in modern India, the legal and constitutional dimensions of social reproduction and in the family, and conceptualizing legal change in group and region-specific family law in India. He has been a TLSI fellow at the inaugural Transnational Law Summer Institute at King's College London in 2015, and has held visiting fellowships at the International Institute for the Sociology of Law in Spain and the Center for Study of Law and Governance at JNU in 2012. And without further ado, I would like to invite Saptarshi to please share his thoughts with us.
Thank you, Tanvi. Good evening, everyone. I'm delighted to be here, and I like Soumya, I had a great time reading the book and preparing my comments for this panel. So the first thing that one notices about the book is from the title, it seems like it's a book about private international law, global Indians and the law. That's the indication that one gets. But then once one starts reading the book, it comes across that it's about private international law, but at the same time, it's substantially about family law. So this is a book that could be of use to both these sets of people, not just practitioners, but also academics. The second sort of noteworthy feature of the book is that it speaks not just to the practitioner, but of course, the practitioner would want to know would want to know about the practical aspects of the law. They would want to know what is the current legal position on any particular issue, and the book serves that purpose beautifully. But it's also of immense relevance to the law teacher. And as Soumya said, that as she was preparing, she was kind of brushing up the law of marriage and divorce, and I had a similar experience of brushing up the stuff that I do in the classroom and checking whether my understanding of the issues were up to date or not. So the book is of use to multiple constituency, both in terms of subject matters and also in terms of the professional spheres that they are in. What I'm going to do is I've divided my comments into three parts. So I'll begin by talking about the content of part 3 of the book, and then I'm going to briefly talk about some of the problems that the chapters raise. Sorry. And then I'll end with some reflections on the presentation and the material that is there in the book. All right. So part 3 mainly covers 3 issues. It talks about economic remedies that are available to married people under the law. Then economic remedies broadly, and then it focuses particularly on maintenance and has a detailed discussion on how the Indian courts have developed the law on maintenance, how Indian courts have interpreted the statutory scheme of maintenance, not just under religion-specific family law, but also under secular provisions such as the Domestic Violence Act and Section 125 of the CRPC. And then in the final part of final chapters of this part, the authors talk about the enforcement of foreign judgments pertaining to maintenance by Indian courts and the approach of the courts, the attitude of the courts towards foreign judgment. Now, there are 2 issues. Theme-wise, there are 2 issues that the authors talk about in this part. One is the manner of computation of the amount of maintenance. And there, courts have over time evolved a formula which is not a fixed formula. So courts look at certain aspects, such as the needs of the person who's claiming maintenance, the means of the person from whom maintenance is being asked, the financial sort of liabilities, the sources of income, and so on and so forth. And it's a flexible framework. At the base of this framework is this idea of fairness, and I think the flexibility relates to this idea of fairness, that you cannot have a fixed framework for computation of maintenance, because situations sort of change from one moment to another. So as far as that is concerned, it's very clear. As far as the enforcement part of the problem is maintenance is concerned, that's an issue in general. That's an issue troubling the law of maintenance in general. So although there is a theoretically and also practically sophisticated way to figure out the amount that one may hope to get from the courts, getting such orders executed is a problem. It has always been a problem. It's a problem for domestic residents. I mean, people who are sort of residing within the country, and it's also a problem for transnational couples in transnational sort of matrimonial disputes. When it comes to enforcement, the nature of the problem is the same. There are newspaper reports of striking things that courts sometimes do. For example, there's one case where the court ordered that the land belonging to the husband, and the land was in the vicinity of where our university is based, it should be auctioned by the local authorities, and then the money recovered should be used to pay to meet the maintenance claim of the wife, because the husband was not accepting the summons. The husband was not responding to the court's sort of direction to appear before it. So from time to time there are these methods which are used by the judiciary to enforce maintenance orders, but that has sort of remained a problem, which takes me to an area of curiosity, as Professor Bakshi mentioned right at the beginning. What could be a possible solution to this persistent problem of enforcing maintenance order? I mean, for some years now, we've talked about matrimonial property rights as an alternative economic remedy. Now, matrimonial property rights do not work as a substitute for maintenance. They do not displace maintenance altogether. Even in jurisdictions where there is where matrimonial property rights are the norm, maintenance still exists as an ancillary remedy. But here in India, on the other hand, maintenance has become the main economic remedy. It's the only economic remedy. Whereas ideally, maintenance has a supportive function. Maintenance is supposed to aid a person in need, but it does not satisfy the requirement of recognizing the equal rights of both parties to a marriage. If we conceptualize marriage as a relationship between equals, then that is not satisfied by maintenance, and at some point maintenance has to be relegated to a secondary position, and the primary position has to be taken by matrimonial property rights. But I also wonder, would matrimonial property rights be a foolproof sort of solution? Would it be a foolproof answer to the problem of economic inequality in marriages? I want to flag that as a question. The second question, again coming from my curiosity, is triggered by certain observations in this part by the authors, that sometimes a spouse residing in a foreign jurisdiction appear before the courts of that jurisdiction to get a favorable order, and then they expect the Indian court to enforce the order. And I'm guessing, so no details were provided in this discussion, but I'm guessing spouses make use of the divorce provisions. So in most Western jurisdictions, there is the divorce regimes are more liberal than we have in India. There is availability of no-fault divorce. But alongside easy divorce, there are other sort of consequences which are more severe. Say, for example, if I am residing in California, I might be able to get an easy divorce, but alongside I'll also have economic consequences there, which are more severe there than we have here. So how does it work out? I mean, is it possible for somebody to to make use of only the favorable provisions of a legal system, but not but kind of dodge the other aspects of the other legal obligations that are cast upon that person. These were questions that came to my mind while reading this part. It's like I said in the beginning, the material is organized in a it's very neat and organized. So it's going to be of use, not just it's going to be useful for the professional, the academic, and I would say students as well, because the presentation is very, very clear and lucid. My in case, I mean, I'm sure the book would go into further editions. One request would be for the authors to include more personal experiences in the text, given that the authors have such a vast experience of working on these issues. It would, I mean, the readers would tremendously benefit from their personal experiences of handling such cases. We know that not all cases end up in law journals. Not all cases are reported. That's number one. Number two, with increasing popularity of mediation, a lot of times outsiders like us don't get to know what actually go on in a case. In some cases, the terms of a settlement are reproduced in the appellate court judgments, but otherwise, even as a law teacher, I don't know a lot of things that happen in matrimonial jurisprudence because matrimonial dispute resolution, because all that is in the domain of mediation. When practicing lawyers author books, I think that's an opportunity for them to transfer some of their accumulated knowledge to us, those of us who are not in the field, so to say. We are mostly in the classroom, and so this would be an opportunity that I would request the authors to include this kind of material, reflections, personal reflections, their wisdom in terms of strategies, what to do, what not to do, because we also know that matrimonial disputes involve a lot of bargaining, and in any bargaining situation, the participants often misjudge their steps. So what's a smart move? What is not a smart move? What may work? What may not work? This kind of sort of information, I think, would also liven up the text, which is already pretty great. But it would just, and I'm of course I'm sort of speaking from a very selfish point of view, because I want to access this information, which is otherwise not available to me, even as a law teacher. So I'll stop there. I think my time is up, and I'm looking forward to hearing from the author and also the others. Thank you.
Thank you so much, Saptarshi. And on that very note, that we would all be privileged, particularly all of us in academics, would be privileged to hear more about the experience and understanding that practitioners bring to the table. I would now like to invite Mr. Anil Malhotra, who is one of the authors of this book, to talk about the next section. A little bit about Mr. Malhotra. He is a practicing advocate based in Chandigarh, who appears at the High Court and Supreme Court. He attained his BSc and Bachelor of Laws from Punjab University and his Master's from the University of London in 1985, where he studied comparative family law at the London School of Economics and law and society at the School of Oriental and African Studies in London as well. For over 36 years, he has continued to act as an Indian expert to render reports in foreign courts on appointment by the bench in overseas jurisdiction. As amicus, he regularly assists the High Court on international family law issues. He has co-authored 9 books so far. And then we have this final book, which is the latest, The Global Indians and the Law, published in 2020. He has a significant amount of published work and has both international and domestic conference participations, besides over 1,000 newspaper columns to his credit. He's a fellow of International Academy of Family Law and an India representative for the Family Law Committee of the International Law Association in London. His expertise with numerous expert reports and professional opinions in issues related to surrogacy, inter-country adoption, nationality, citizenship, marriage, divorce, maintenance, and succession involving global Indians and foreigners, which he has, along with Mr. Ranjit Malhotra, kindly translated into this wonderful comprehensive text. He has also conducted a number of litigations on inter-country parental child removal matters. And as amicus, his report on the inter-country parental child removal is part of a Punjab and Haryana High Court judgment, making reference to the Law Commission of India. And the recommendation was made that there needs to be a consideration to sign the Hague Convention. Mr. Malhotra has also served as a member of the Committee of Ministry of Women and Child Development of the Government of India to examine legal issues involved in resolving problems of parents and children involved in interparental, inter-country child removal. And the report was submitted to the Government of India in 2018. He has also lectured as a resource person at a number of institutions, including the National Judicial Academy in Bhopal and Chandigarh, the Chandigarh Judicial Academy, and various national law universities. And without anything further, I would like to invite Mr. Malhotra to please share his thoughts with us on the next part of the book. Mr. Malhotra, could you please unmute?
Thank you, Tanvi, for that brilliant introduction. And first of all, I wish to express my gratitude to Professor Bakshi and Professor Rajkumar for hosting this discussion. Global Indians. I rhyme with Jindal Global University. So the word global is in common with us. And most brilliantly, the master of the spaceship is whom I call Professor Rajkumar, whom I call Superman, whose boundless energy, marvelous talent, growth, and capacity to imbibe knowledge and make Sonipat a world-class destination for academics of the highest quality with the most brilliant academics is what could be the most befitting tribute of, as Professor Upendra Bakshi thinks, who is a global Indian. So the global Indian is actually in the middle of nowhere in Jindal, thanks to Superman and thanks to his marvelous energy of multiplying. And over a period of 5 years, I have seen him grow 3 times. And the condition is in the next 10 years, it has to grow at least 20 times. And I'm very hopeful that probably next we will be having an international terminal called Jindal Global University Terminal, which will all the time being jet-setting people from different parts of the world. And people will stop going to Oxford, Cambridge, Harvard, and Yale, and people will be going to Jindal Global University, because that is where global education will be in the future. So with these few words, and which I rhyme with my book, I bring to you 3 different topics in 3 different areas, which are new world, new age jurisprudential concepts. And as Professor Upendra Bakshi says, we have traveled a long way from the phrase "Jo padega dukhi, wo hoga dukhi." So from there, we have traveled to a long way where, as Professor Bakshi very rightly puts it, curiosity. I am faced with curiosity every day. Human relationships pose such peculiar problems of marriage, divorce, child removal, adoption, surrogacy, that you are at times baffled by what to do, what to say, and how to figure out. But then courts want solutions. You have to think out of the box. And as Professor Satpashi Mandal very rightly put it, you have to carve, you have to innovate. I think the job of a lawyer is more like a craftsman or as a tailor to cut a cloth out of a fabric for size, tailor-made to requirements. Now, it is in this context I talk of child removal, adoptions, and surrogacy. I find myself facing new challenges every day in these three areas, and I will spend 4 to 5 minutes on each of these topics, though they are vast. Now, as far as child removal is concerned, India spread over 3.28 million square kilometers with 28 states and 9 union territories and 1.3 billion Indians, 30 million of which live in 200 countries abroad. When we have matrimonial disputes, we remove children across borders. We do not recognize parental child removal as an offense. Though a Delhi High Court judgment tried to expound it as kidnapping under 361 IPC, but I squarely think that doesn't fall in. Interparental child removal is conventionally not a wrong or an offense because under our personal laws, the parent is the natural guardian. So if a child is taken away by a parent, it is not a wrong. But then, where are we in terms of the world? We are on a tiny island and we have been labeled as a haven of child removal. 100 countries have signed the Hague Convention on Civil Aspects of International Child Abduction 1980. We have not. So whenever there is a dispute, a child is brought to India, child is parked here, we look at the best interests of the child, we do not return the child to the country of the habitual residence, and therefore children are not allowed to come to India anymore whenever there is a matrimonial dispute. This is a stalemate. Exercising the parents' betray jurisdiction, our courts are very vibrant and they really stretch themselves with some brilliant judgments which have come in the recent past to evolve a shortcut method and return the child to the country of the closest contact on the best interest principle by following more or less comity of courts principle. But there has been a divergence of views from different points of time of different benches. So there is no consistency. The closest I have got to is, with the assistance of the Supreme Court, is evolving a mirror order jurisprudence, whereby I have been able to prevail upon the court with great difficulty at times, that if the Indian courts were to pass a mirror order, which is mirrored in a US jurisdiction or a foreign jurisdiction, then the spouse who has removed the child will be permitted to go back with protections. And maybe if we start adapting a mirror order jurisprudence culled out by a jurisprudential concept till we sign the Hague Convention, we may be able to move forward in this global problem of child removal. If there is no peace at home, there is no harmony in the family, you cannot grow commercially. Howsoever powerful or motivated you may be as a scientist, as a banker, as an economist, or as a doctor, if you have a problem relating to your child, you will not be able to work. So unless we seriously look at this issue with a deliberated point of mind, we will not be able to grow in terms of what we think we can grow exponentially if we are going to have change of intellectual property between different destinations. So this is a peculiar problem which has grown so fast, but sadly we have not tried to address it. Report number 257 of the Law Commission, authored by Justice A.P. Shah, was a brilliant move to bring in concepts of joint parenting, shared custody, and so on and so forth. But it gathers dust on the shelves of all archives, and we have not moved on. We are sometimes left to a Guardian and Wards Act of 1890, a colonial legislation, as a fallback into going to see if we can become a guardian to our own natural born child, which to foreign courts and foreign judges is sometimes absolutely baffling. So this is a dilemma which has a serious jurisprudential issue which needs to be addressed. I was a part of a 13-member committee of the Government of India. We've submitted a 2-volume report. We have even suggested that we should make a bill, recognize it as a wrong, we should sign the convention, but our parliament is very busy doing a lot many other things. So we are left where we are on this issue as it is. Then the second issue, which has now seen a spurt of litigation, is inter-country adoptions. Now, starting from the Supreme Court judgments in Lakshmikant Pandey 1, 2, and 3, the Supreme Court very effectively managed to stop the trafficking of children, because India has more than 12 million orphan children, and child racketeering, child abuse, smuggling of children to be sold in foreign places, pedophilia, these were very common problems. So the Juvenile Justice Act of 2000 was amended, and we now have the Juvenile Justice Care and Protection of Children Act 2015. Under it, we have the JJ rules and we have the adoption regulations 2017. Because we signed the Adoption Convention of 1993, and because India is a signatory to the United Nations Convention on the Rights of the Child, we were perforce, we got into amending a lot of the legislations and we brought in a lot of child rights. So the UNCRC basically sees the child as an individual. A child is a person, a child has a right to a home, a child has a right to a nationality, a child has a right to a citizenship, a child has a right to family life. Now this is a concept which, until urged and argued before the courts, had never found recognition. So seeing the child as a person, not as a chattel, not as a commodity, not as a trophy, which the child invariably is in litigation of matrimonial nature, there has been a lot of focus on children in need of care and protection. So in the Juvenile Justice Care and Protection of Children Act 2015, we carved out a chapter on adoptions and we took on an adoption regulations. So we have streamlined a process of adoptions by creating and recognizing as the Hague Convention on Adoption that requires a central authority. So the central authority is a body which coordinates with central authorities all over the world. So wherever you wish, wherever you are, you apply to the central authority, you fall in queue of the system that is carings, and you are assessed for a child to be given to you. And after that scrutiny process, the child is given to you in adoption after there is a NOC by CARA and there is a court order permitting you to adopt. So far, so good. But the crisis which is now coming in is, as I have been asked to assist as an amicus twice, and I see a judgment of the Delhi High Court come in recently, and I'm going to discuss it on a platform in Kerala tomorrow, with Justice Dai sitting as chair, is how do you reconcile adoptions under HAMA? Now, under personal laws of all communities, particularly Hindus, Christians, and Muslims don't allow, once an adoption is done by giving and taking, it's irreversible. There is no court requirement, there is no written deed, it's just datta homan, giving and taking. The problem comes when there is a adoption under HAMA by the parents giving and adoptive parents taking, and the child is to be taken out of India. CARA refuses to give the NOC, saying follow the procedure under the JJ Act. Now, if I have to go under the JJ Act, which is meant for orphan, abandoned, and surrendered children, the ideology is different. It is the CARA is stepping in as a parent, but when the parent is actually giving, where is the need for CARA? This is a question which the courts have posed and answered to say Section 56(4) exempts all HAMA adoptions from CARA application. But then the protagonists of CARA argue that every adoption inter-country is governed by the JJ Act and the adoption regulations. So how do you resolve this dilemma? Justice Pratibha Singh, in a judgment authored last week, has asked CARA to resolve it and say you have to frame guidelines. There is a dilemma. The question is, if a personal law adoption is saved, you have to look for the answers within the Hague Convention. And rightly so, the High Court has done it. Article 37 of the Hague Convention on Adoption says that domestic adoptions under law of the country in which the child is to be adopted, if it is so provided, that is saved. But then, should CARA step in as an overtaking authority just to establish its supremacy? The answer is no. And I see a problem there because bodies like CARA, I think, in my humble view, should be headed by an honorable judge, at least, if not a retired Supreme Court judge, the Chief Justice of the High Court. You cannot have a CEO of CARA who is a non-legal person because he doesn't understand the nitty-gritties. Another place where
So
I
sorry to interrupt you. Just wanted to let you know that if you could wrap up.
Yeah, quickly, 2 minutes.
Yes.
Now, there is another flaw which CARA has brought in is they have given the approval of adoption orders to executive magistrates by changing the definition, which I think is fatal. Now, I jump on to surrogacy. We have done a wonderful job in adoptions, but we have made a mess in surrogacy. When surrogacy from 1995 till 2020 is a 25,000 crore industry with 2 lakh clinics all over the world, all over the country, sorry. But where are we in terms of the law? We have gone down from opening it to closing it. Surrogacy is restricted to married Indian couples with 5 years of marriage and proven infertility. OCIs, PIOs, NRIs, all out. Where is the law going? We have made a regulated process in adoptions, but in surrogacy, we have gone wrong. We have disallowed surrogacy. We allow adoptions to all parents, irrespective of marital status, by virtue of the adoption regulations. But we do not allow surrogacy for single persons, persons in same-sex relationships, and so on and so forth. So there is a clear imbalance in thought process. The courts step in to interpret wherever necessary. If I have an embryo lying, or I am a foreign national, it is not to be returned to me, I should be given back. But the government says, no, the embryo can't be given yours. It is my property. The Bombay High Court has said, return it. So with these few thoughts, and to keep the pot boiling, the curiosity going, we will develop more and more, enlarge more and more, and hopefully we will have Professor Rupendra Bakshi soon and Professor Mandal looking at more interesting things, Professor Soumya having more anecdotes to see, and Professor Tanvi being our host again, and Superman bringing in new concepts of global universities. Thank you.
Thank you so much, Mr. Malhotra. Before we move on to the concluding portion, which Professor Raj will be taking up, there are a few questions, and although there's a paucity of time, I think it's only fair that our participants should be able to have their questions addressed. So I'm just going to put a few of the questions here very quickly. I see that Professor Raj is here. Professor Raj, I would like to invite you to speak on the concluding portion, but you must give me the opportunity to introduce you to everyone who is participating. Although really to introduce Professor Raj after Mr. Malhotra's lovely introduction is quite difficult to do. And so I will just let everyone who is participating and our audience know that Professor Dr. C. Rajkumar is our Vice Chancellor, a Rhodes Scholar, and the founding Vice Chancellor of OP Jindal Global University.
Tanvi, that's good. That's enough. It's been a fascinating discussion, and thank you very much, Tanvi. And so wonderful to hear Saptarishi and Soumya, and of course, our collective mentor, Professor Upendra Bakshi. So good to see him reflect on it. Congratulations to both Professor, I should call him actually Professor Anil Malhotra and Professor the other Malhotra. In a way, in fact, it's a very. I'm amazed by the fact that the Malhotra brothers have spent so many years of their, important time as lawyers, legal practitioners to not only produce these extraordinary books, but also to take so much time and effort to articulate these ideas that will speak to not only the jurisprudence that have been developed in India and around the world, but also to speak to lawyers and judges and law academics. So let me at the outset congratulate both Mr. Anil Malhotra and Mr. Ranjit Malhotra for this fascinating book, The Global Indians and the Law. I must confess that I have not read the book. I know that my colleagues have read and articulated, and I could get a good sense of what the broader themes of the book is. I'm supposed to talk a little bit about one of the chapters, which I did read, and I don't, the organizers are very smart to give me, knowing pretty well that I would have little time to read anything. Probably one of the shorter chapters have been given to me. So I'm grateful to them for choosing chapter 21, which is entitled Real Justice and Virtual Courts. I was quite intrigued by the title of the chapter itself, using the word real justice in virtual courts at a time when all of us are struggling to really understand and appreciate what is real and what is virtual, and the boundaries of real and virtual are in many ways at some levels collapsing, and all of us are part of that experience itself. Nevertheless, what this chapter has done is it has given a tour de force on the evolution of jurisprudence at these extraordinary times when effectively what we would understand before March 2020 as adjudicatory processes that were happening in a more physical manner simply did not come to be. And that made this particular situation quite unique, quite extraordinary. And the authors have taken a lot of effort to really articulate the evolution of the courts in relation to matrimonial matters and also other related matters using the virtual court system that we have developed. But while I will come back to that part of it shortly, I want to mention that it's one of those unique crises that humankind has faced, or rather continue to face, where there is no part of human society anywhere in the world was completely insulated from the pandemic. And that means every possible systems that were available had to innovate, had to reimagine, and had to provide alternative ways by which some degree of, prior normalcy could be restored and continued. While all of us will have serious objections to the way in which many forms of justice delivery mechanisms have been effectively implemented, even in a pre-pandemic context, and that is clearly visible. The fact that the pre-pandemic context, not just the kind of issues that the Malhotra brothers have been talking about, but even in other matters, if there were, say, 3 crore cases pending in various courts just before the pandemic, I believe now the pendency has increased to over 4.5 crores, which is an outcome of the pandemic itself. So there are huge issues of access to justice that is writ large, which is independent of the pandemic itself. But what is quite extraordinary, as the book has developed through various chapters, is that the issues that remain important even during ordinary times, if at all, has acquired greater importance during these extraordinary times. And what role does judicial institutions have in responding to these challenges? The authors, because of their vast knowledge, understanding, and experience of jurisprudence developed by Indian courts, but also others, have made reference to other experiences, including in Australia, but also in India. And all of those experiences, resonate. But the point that I mentioned earlier, which is that this is one of those unique moments in human history when simply justice systems around the world could relate to each other, and were attempting to address the kind of challenges that all of us were collectively addressing during these times. I would like to say that there are 5 things that I believe the fundamental point that Malhotra brothers are making in chapter 24 effectively argues, and I will articulate that in that manner. The first is that the chapter recognizes the inevitable imperative of access to justice. Regardless of whatever time we are living, we need to recognize that access to justice is important, and every effort needs to be made by all stakeholders of the justice system to do their best to ensure and promote access to justice. The second point that the chapter 24 is making, which is an obvious point but still needs to be made, is that rule of law is indeed paramount at all times. This is not one of those moments when rule of law can wait. If at all anything, the emergent situations that we have faced during this global health crisis has made the marginalized and the vulnerable even more vulnerable when it comes to their abilities to access existing systems of justice. And hence, it was important for rule of law to prevail, and that all judicial institutions need to do their best. The third aspect, which I think is a very strong argument about the role and importance of virtual courts, which I think is all of us are beginning to recognize, is that the cost factor. In fact, as one reads more about the issues covered by the global Indians and the law, it also brings home the point that all of us who are in the broader discipline of law recognize how difficult it is to access justice, not so much because of the fact that we don't know how to access it, but to a large number of people, it remains prohibitively expensive. And so one hopes that if virtual courts can create opportunities for democratization of the justice system, and it'll help in reducing costs, particularly for those people who simply can't afford it, then I think there is a even more stronger case for promoting virtual courts that transcends the COVID-19 crisis, but even goes beyond it and becomes a unique and an independent and hopefully a sustainable institutional mechanism for promoting justice. And that's why there is a case for, and I think, and I'm not going into the details of it, there is a whole set of writings and reports that have come about. The Supreme Court of India has also produced a paper. The Vidhi Center for Legal Policy has a fantastic strategy paper titled Virtual Courts in India, a strategy paper. And there are other writings as well, not just in India, but also around the world. All of them are very instructive. And for those of you interested in knowing more, I invite them to make references to that as well. The fourth aspect, which I think is very important, and particularly on the kind of issues that we are talking about, custody and surrogacy and adoption and transnational implications of these issues, is the speed and the need for efficiency in the justice delivery mechanism. The fact is, these matters are hugely time sensitive, and hopefully, if we can develop a more sustainable framework for promoting virtual courts even beyond the pandemic, then I do believe that this can actually promote and significantly improve efficiency, and the justice delivery mechanism on these matters can be improved. There are other related aspects of travel and logistics and coordination and even multi-stakeholder involved in many of these disputes. And all of this could be made much, much easier if we can address the speed issue through the virtual courts. That's the fourth point. And the fifth one is in many ways the elephant in the room, which is about the the technology, to what extent it should be empowering and not disabling. Because the fact remains that technology it's not something that everybody can take it for granted. There is so much of data that has come about. While I must say that overall, the human ability to embrace ingenuity and innovate is quite extraordinary. A relatively small university like us, within a week, we moved into online teaching, and despite all its challenges, our faculty members have devoted the last 18 months with little or no vacation, little or no breaks, continuously engage in teaching and adopting all kinds of methods to ensure that the teaching project is not undermined. The students have been adaptive, have been understanding, have been engaging, and hugely deprived of the opportunity to be on campus and yet continue their teaching. And by the way, this is not just a phenomenon that is happening in Jindal Global University. There are schools across India and around the world, colleges and universities. They have all done that. Now, of course, this is not something that everybody has been able to do because of the fact that technology is not an inclusive phenomenon. The fact remains that despite all these developments we have seen, less than 15% of Indian households have three things that are essential for having a reasonably, meaningful virtual experience, whether it is in classes or probably in courts too. First is that a reasonable and effective Wi-Fi access, reasonable and effective electricity, and reasonably working equipment. So in many ways, technology can be a hugely discriminating element in our effort to seek justice, and as what Malhotra brothers call real justice. But if we can address that, I do believe that the virtual court system will play an enormous role in addressing the huge challenges of global engagement, including transnational challenges of bringing people into a courtroom and to provide justice. It requires a significant reimagination of the existing justice delivery mechanisms for it to be effective. Most of all, it requires serious investment, including public policy initiatives, training and capacity building at all levels, including lawyers and judges, but also sensitization of the unique circumstances under which the people who are accessing this form of justice need to go through. These are some of the big issues that I believe the virtual courts will have to go through. I think there has been a shakeup through this COVID-19 crisis. I sincerely hope that we don't end up into a normal, which is like what it was before March 2020. We use this opportunity to reimagine and innovate and use some of these mechanisms to democratize access to justice. In fact, I was recently talking to a bunch of our students, and I was amazed by the opinion by them that so many students have been able to more actively participate in online education because they end up feeling more empowered. They felt that their voice was being heard more effectively. Their own reluctance and even shyness that could have been brought through stronger peer group influence in a physical setting had been overcome. I also hear my lawyer friends, young lawyers, having greater opportunity to present themselves better in courts, not just in lower and high courts, which have those facilities at some level, but even the Supreme Court. Again, there is an extraordinary democratization of access to justice by people who were in a position to do so. The sort of the big lawyer, manly presence, if I may call it, has given way to opportunities for young men and women to present themselves more in a more engaging manner. So there are huge, interesting developments that are happening. It's too early to make large sweeping judgments about it, but I do believe that it has brought a greater degree of diversity and inclusion and democratization into the process leading to access to justice. And that's where the Malhotra brothers have identified a very important room for the future. So with those words, I want to congratulate both Anil and Ranjit Malhotra for their fascinating work. I hope that one day when I stop doing what I am doing, I can spend more time reading the book. Thank you.
Thank you so much, Professor Raj. I am aware of the fact that we are really running short on time, but if I could just address one quick question to Mr. Malhotra from some of our audience, which is, how have international residents, NRIs, been affected by the pandemic, in particular, those people who were in India and then have not been able to go back because of the pandemic, and now are being taxed as resident Indians and are therefore also a little bit stuck in India at present, even though they actually are non-residents as far as their occupation and living is concerned. So if you could shed some light on the impact of the pandemic.
Thank you, Dharmi. I think the biggest problem has been Australia. A lot of Indians have been stranded, could not go back. Australia is still enforcing very, very strict conditions. And there have been very hard cases. I know, for instance, personal instances of a very eminent educationist, Professor Lord Rana, who was in Sanghol. He's a British national, a member of British Parliament, lives in Ireland, manages a huge business. But he was stranded in Sanghol, where he runs a huge educational complex, and he could not go back. And when he went back, he had to be quarantined. I think the quarantine was the biggest problem for people. You had to stay in hotels for 15 days. You could not go out. You were locked in confined spaces. The bigger working class which was hit was the Gulf community, who could not go back, who lost earnings, who lost wages. It was a dilemma for a lot of people. A lot of us depend on income from foreign jurisdictions. And then there were a lot of people, families which were stranded, children, women who were left behind and could not move. And worst of all, I think the biggest sufferer was Professor Rajkumar, because he couldn't fly anywhere in June. This is the first time I've seen him in Delhi, in Sonipat in June and July. Otherwise, he had 50 meetings in 20 different countries, and he was all over the globe. So there was nothing anybody could do. I wish probably Branson would have lent him his jet, but then he could not have still flown. So Tanvi, with those words, I think that answers the question.
Thank you so much, Mr. Malhotra. I just wanted to conclude this extremely illuminating discussion with a few thoughts. And it has been my privilege to be a moderator for this discussion. As a young student, as Professor Bakshi was saying, that curiosity always drove us to think about family law, and in particular, international problems in family law. Maybe because we were the generation that grew up with Dilwale Dulhaniya Le Jayenge and so on and so forth. It was always the most entertaining to us to think about how and what are the implications of being an NRI, being a global Indian, as you have so aptly put it, and to now, after so many years of joining law, get to have this more in-depth understanding. It has been really a privilege to be a part of this discussion. I want to extend my thanks first and foremost to Professor Upendra Bakshi, without whose guidance I really would not have been able to envisage this panel together. I, as always, would like to thank Professor Rajkumar, whose guidance and support is essential to anything that we do in the university. I would like to thank Professor Soumya Uma and Professor Saptarshi Mandal for joining us and for sharing their thoughts and their expertise as academics working in this area. And last but definitely not the least, I would like to thank Mr. Anil Malhotra, because without you and of course Mr. Ranjit Malhotra, this book would not be possible and we would not be here getting to participate in this very fascinating discussion. So thank you so much everyone for your presence and for your interest. And my apologies that we haven't been able to take every question because of a paucity of time. Thank you.
So just one concluding remark.
Yes.
There used to be a song, Pardesiyon se akhiyan milana nahi. Who has proved this phrase and the song wrong? Global Jindal University and Professor Rajkumar. Thank you very much.
Congratulations. Thank you.
Thank you.
Very nice.
Yeah. शुभम जी आप लाइव रिकॉर्डिंग अब बंद कर सकते हैं.
Thank you. Tanvi, thank you. You did an excellent job.
Thank you so much, sir.
And I'm very grateful to Soumya ji, who crystallized everything in a whirlwind tour. It was like a whirlpool, you know. The more she did and the more